before hiring a foreign employee, Part 2.
In my first video on what to ensure before hiring a foreign employee, we have checked in which cases a work permit is not mandatory, who is concerned by the obligation to hold an authorization of work. My future employee presented me with his work permit. Is that enough to be able to hire him? Now we will deal with the following situations. What to do if my future employee does not have a work permit in France? What are the financial commitments of the employers when hiring a foreign worker? What are the penalties applicable in case of concealed work? What to do in case of discovering the irregularity after hiring? What to do if the future employee does not have a work permit in France? If the person does not have a residence permit authorizing him to work, it is the responsibility of the employer to take care of the procedures for obtaining the work permit before any hiring by making a request to the trust. The employer submits a file which must contain, among other things, a CERFA document. This CERFA will depend on the employee's residence in France or outside France. To issue the work permit, the prefect considered a certain number of elements such as the employment situation, the employer's compliance with the labor legislation, etc. The prefect notifies his decision to the employer and to the foreign worker. If approved, the prefect sends the work permit to the French Office for Immigration and Integration, OFII. This transmission only concerns contracts lasting more than 3 months or seasonal employment contracts. Now, what are the financial commitments of the employer when hiring a foreign worker? A tax is due by the employer who hires a foreigner when this foreigner enters in France for the first time or when he is admitted staying as an employee for the first time. The tax is due for work permits covering periods of more than 3 months, except for seasonal agricultural workers for whom it is due from the first day. The tax must be paid within 3 months from the issuance of the required documents and visas and the documents necessary for the exercise of the professional activity intended upon first entry into France from abroad. The issue of the work permit for the first admission to stay as an employee, its amount is fixed by decree based on the level of gross monthly salary of the employee. For hiring a person equal to or greater than 12 months, the tax is 55% of the salary paid to the foreign worker, considered within the limit of 2.5 times the minimum wages. For temporary employment of more than 3 months but less than 12 months, the tax varies according to the salary level. Its amount is fixed by decree. Since January 12, it is 74 euros to 300 euros. Be reminded that it is strictly forbidden for the employer to ask a reimbursement for this amount paid to the OFII to the worker. Now, what are the penalties applicable in case of concealed work? An employer who employs an employee in an irregular situation risks, as a natural person, a fine up to 15,000 euros and 5 years prison, knowing that the fine is applicable as many times as there are illegal employees. This penalty is increased to 10 years and a fine of 100,000 euros when the offence is committed in an organized gang. Additional penalties may also be imposed, such as a ban on exercise professional activity or exclusion from public contracts for a period of 5 years. Legal persons, companies, may be charged a fine up to 75,000 euros. In the event of a fraud or false declaration to hire a foreigner in France, the employer risks 1 year's prison and a fine of 3,000 euros. In addition, hiring a foreigner in a professional category, profession or geographical area other than those mentioned in the work permit is punishable by a fine of 1,500 euros. What to do in case of discovering the irregularity after hiring? Irregularity does not in itself constitute serious misconduct, but if the employer discovers that one of his employees is in an irregular situation, he must dismiss his employee for this reason. He will not have to follow the dismissal procedure, but he must pay the dismissed employee the paid leave allowance and a lump sum equal to 3 months' salaries or the dismissal compensation and notice if it is greater than the 3 months of salary. These rules may differ depending on either an employee is on a fixed term or permanent contract. My purpose with those 2 videos on this subject is to highlight that it is possible to hire a foreign employee. Provided you follow the different steps, your CPA firm or your lawyer can assist you with this process.